State Attorney, and Mr. Blanzi Reno. My lords, for the petitioners, we have Mr. Nicholas Opio in the consolidated petition, Mr. Derek Twasibwe, Mr. Henry Biansi, Mr. Paul Waswa.
Petitions number 14, 15, 16, 18, actually 85 of 2023 as well is ready, and the court has given one court judgment. It is over 200 pages. We have chosen to read a summary of the judgment, but the judgment is ready for the parties and the advocates and will be dispersed to them immediately after reading the summary. This is the summary of the court judgment. Introduction. This consolidated petition essentially challenges provisions of the Anti Homosexuality Act for the alleged contravention of human rights and freedoms that are guaranteed under the Uganda Constitution and international human rights instruments, which Uganda is a party. The petition is opposed by the Office of the Attorney General, Messrs. Martin Semper and Stephen Langa, and the Family Life Network Limited. It did also benefit from an amicus brief filed by the Secretariat of the Joint United Nations Program, HIV/AIDS. The parties framed the 14 issues for the court's determination. 5 of the issues were procedural and 9 were substantive. Issue number 1, alteration of previous court decisions. 1. The petition has contended that the enactment of the Anti Homosexuality Act 223 had the purpose, objective, and or effect of altering the earlier decisions of this court, which they quote. This is alleged to constitute a violation of Article 95 of the Constitution. 2. In Professor J. Oroko Nyango and others versus the Attorney General, the court adjudged the Anti-Homosexuality Act of 2014 to have been passed without the requisite quorum. Given that no determination was made as to the constitutional rights of the petitioners in that case, it cannot be suggested that the current Anti-Homosexuality Act changes or obliterates undeclared rights. Similarly, the Kasha Jacqueline case did not interrogate the constitutionality of homosexuality vis-a-vis the fundamental rights and freedoms enshrined in the Constitution. It follows, therefore, that the current Anti-Homosexuality Act would not, ipso facto, negate the legal rights of litigants in that case. The Victor Juliet Mukasa case was equally steeped in human rights violations rather than homosexuality per se. Therefore, the current Anti-Homosexuality Act would not necessarily abbreviate the trial court's decision. We find that the enactment of the Anti-Homosexuality Act of 2023 did not have the effect of altering previous court decisions. Consequently, the Anti-Homosexuality Act was not passed in violation of Article 92 of the Constitution. Issue number 1 is therefore resolved in the negative. Issue number 2, charge on the consolidated fund. The majority position in Male H. Marilizi and others versus the Attorney General Consolidated Constitutional Appeal number 2, 3, and 4 of 2018 and reported was that Article 93 prohibits charges on the consolidated fund that cannot be accommodated within existing budgetary provisions. In this case, it has not been demonstrated by the petitioners that the implementation of sections 16 and 17 of the Act would impose a charge on the consolidated fund or alter any existing charge. The argument that the prison service, probation, social and welfare officers would be paid for the man-hours spent rendering rehabilitation envisaged under Section 16 is speculative and not supported with proof that the necessary public servants would in fact be paid on man-hour basis rather than within the pre-existing, pre-budgeted and unaudited prison service wage bill. 5. In Marriage Mabilizi versus the Attorney General, the majority position was that the amendment to the original bill that had the effect of creating charges on the consolidated fund could be severed from the resultant act as opposed to striking down the entire act on that account. It follows, therefore, that had the petitioners in this case proved that Section 16 that was introduced to the bill by way of amendment did in fact create a charge on the consolidated fund, it would have been liable to suffer the same fate of severance from the Anti Homosexuality Act. However, insofar as clause E and F of the certificate that was availed in this case do indicate that expenses from the Anti-Homosexuality Bill could be accommodated within the budgetary framework for the period in question. They do comply with Section 76(2) of the Public Finance Management Act. To that extent, the Certificate of Financial Implications does abide the dictates of Article 93 of the Constitution. In the result, we find no violation of Article 93A(2) of the Constitution. Therefore, issue number 2 is resolved in the negative. Issue number 3, public participation in legislative processes. Article 36(1) of the Uganda Constitution recognizes Ugandans' right to participate in the governance of the country, either individually through a referendum or by representation through their elected representatives. We do not construe Rule 189 of the Parliamentary Rules of Procedure to impose a constitutional obligation upon Parliament's Committee on Legal and Parliamentary Affairs to undertake the extensive consultations alluded to by the petitioner. Article 1(4) and 36(1) of the Uganda Constitution would appear to relegate matters that require the individual participation of Ugandans to specific questions framed under national referenda. 8. Article 36 ought to be construed within the confines of the sovereignty of the people and their right to express themselves on how they should be governed, as articulated in Article 1(4) of the Constitution. The right of sexual minorities to participate in legislative decision-making processes would similarly be by representative participation through their elected representatives, as well as the submission of views to the applicable committee of the House. The evidence on record depicts overwhelming support for the bill at committee stage and in the full House. Therefore, we do not think that more extensive consultation with sexual minorities would have led to a different legislative result. Consequently, the committee cannot be faulted for considering it neither expedient nor necessary to engage in further inquiries on the bill, as it is well entitled to do under Rule 129(2) of the House's Rules of Procedure. We therefore find no violation of Articles 1, 2, 20, 36, 38, 79, and 94(1) of the Constitution. Issue number 3 is resolved in the negative. Issue number 4, conduct of the Speaker of Parliament. The petitioners contend that the conduct of the Honorable Speaker of Parliament during enactment of the Anti Homosexuality Act influenced the debate on the bill under 77 of the Parliamentary Rules of Procedure, which prohibits the Speaker from participating in parliamentary debates. Meanwhile, the conduct of parliamentary debates is not addressed in the Constitution, but under Part 12 of the Parliamentary Rules of Procedure. 10. We do not think it was the intention of the framers of the Constitution that every fraud arising from parliamentary rules procedure would constitute a constitutional violation simply because the rules were not enacted under Article 94(1) of the Constitution. Whereas the Speaker's conduct might indeed have Hello? Are we still okay? Whereas the Speaker's conduct might indeed have depicted undue partiality, that would have been a matter for the House itself to address under its procedural rules. A violation of Rule 77 of the Parliamentary Rules of Procedure would not amount to a constitutional violation. 11. The case of Honorable Francis Zake versus the Attorney General, Constitutional Petition number 3 of 2022, and reported, is inapplicable to the circumstances of this petition. The bone of contention in that case was the impropriety of the Speaker presiding over a matter in which she was a de facto complainant. In this case, however, it is her alleged partial guidance of the House debate that is under challenge. We therefore find no violation of Article 89(1) of the Constitution. In the result, we find no merit in issue number 4 and hereby resolve it in the negative. Issue number 5, constitutional prescription against same-sex marriage. It has been alleged that the procedure adopted by the House during that constitutional amendment process violated Rule 126 of the Parliamentary Rules of Procedure and therefore Article 94 of the Constitution. However, the affidavit evidence of the Clerk of Parliament establishes that there was no breach of Rule 124. It demonstrates that after the first reading, the bill was sent to the Legal and Parliamentary Affairs Committee. After the second reading, the bill and the report of the committee came up for debate before the Committee of the whole House. Honorable Abdul Katutu moved a motion for Clause 11(2)(a) of the bill to be made prohibitive rather than regulatory, hence the introduction of Article 31(2)(a) of the Constitution. There is nothing on record suggests that the bill at the second and third readings was not supported by 2/3 of the MPs present and voting, as prescribed in Article 26 of the Constitution. The fact that the committee did not specifically recommend an amendment to Article 31 of the Constitution neither barred the honorable members from moving his motion or the House from considering the motion. Parliament reserved the right to accept, reject, modify, or amend the committee's recommendations. We therefore reject the view that Article 31(2)(a) of the Constitution was enacted in breach of Article 1, Sub-Article 1 of the Constitution and Rule 124 of the Parliamentary Rules of Procedure. We find no constitutional violation of either Article 1, Sub-Article 1 or Article 94, Sub-Article 1 of the Constitution. With regard to the alleged breach of Article 44 of the Constitution, we found no evidence whatsoever of the inhuman and degrading treatment occasioned by the prohibition in Article 31(2)(a) of the Constitution against same-sex marriage. The best evidence in this regard would have been from persons that have been denied such a marriage, but none was forthcoming in this case. We thus find no merit in this allegation and accordingly find no violation of Article 44(a) of the Constitution, Issue number 5 is accordingly resolved with issues. Issue number 6, principle of legality. The principle of legality is enshrined in Article 28, sub-Article 12 of the Constitution. That constitutional provision was interpreted in Attorney General versus Salvatore Abuki, 1999 Uganda reports, to require the legislature to legally define a criminal offense without necessarily defining each word in the law. The principle further proposes that where a statutory provision is not vague or ambiguous, it would be constitutionally valid. But where no intelligible standard can be deducted from the wording of a statute, there would be no legally defined offense as required under Article 28, sub-Article 12 of the Constitution. In this case, we read no ambiguity in Section 6 and Section 14 of the Anti Homosexuality Act. Furthermore, the cross-reference to the rest of the article under Sections 9, 14.1 and 15.1 of the Act in order to ascertain other criminal offences thereunder would not in itself render the impinged provisions vague or ambiguous. Similarly, Section 7 of the Act clearly creates the offence of publication of a victim's identity and prescribes the penalty thereof. Although not defined in the Act, the technical term trimedis faristis simply relates to the tripartite broadcasting mediums of television, radio, and print media. Given that these are typical broadcast and publication mediums, we find no uncertainty in the reference to that term. 17. It is the duty of courts to construe statutes so as to give effect to the objective of legislature and do justice to the parties. It is only where the ambiguity or uncertainty defies judicial interpretation or is incapable of meaningful construction that a statutory provision would be declared void on account of vagueness. In this case, the plain, natural, and ordinary meaning of the key words in Section 11 of the Act is sufficient to clarify the nature of the conduct that is prohibited under subsections 2A, B, C, D, and E of that statutory provision. On the other hand, Section 14 entrenches the mandatory reporting of suspected offences under the Anti-Homosexuality Act. We do not find any ambiguity or uncertainty in the evidential standard of reasonable suspicion either. It simply denotes suspicion that is grounded in bona fide, genuine, and objective reasons. That would negate any malified and subjective reporting that is prescribed under Sections 15 of the Act. We are satisfied, therefore, that Sections 14 and 15 of the Act are neither contradictory, nor vague, nor uncertain. We therefore resolve issue number 6 in the negative. We shall commence our interrogation of the rights that have been involved under issues number 17 to 15, number 17 with the explanation of issue number 8. Issue number 8 is on human dignity. The petition has contained that some provisions of the Anti Homosexuality Act are inconsistent with the right to human dignity and protection from inhuman treatment. Under international law, the concept of dignity is broader than the imperative or respect of human dignity that is encompassed in Article 24 of the Constitution. Rather, dignity is considered to manifest as a right, a principle, or a legal value. The petition before us invokes human dignity as a substantive right that is the fundamental source of human rights. 20. The evidence on record is that the Anti Homosexuality Act was enacted against the backdrop of overt superimposed homosexuality on Ugandan culture by the recruitment of children into the practice. The anti-homosexuality law thus sought to reflect societal sentiments on the subject of homosexuality. We take the view that the right to dignity ought not to operate in the abstract, but within the societal, political, cultural context of a society, particularly their communal culture, norms, and values. It follows then that conduct that deviates from the cultural manifestation of any life, language, literature, music, religion, traditions, and customs operates at cross purposes with the right to human dignity. In Uganda, such societal considerations are stipulated in Article 8A, which ties the governance of the country to national interest and the common good, as opposed to individualistic considerations. In addition, Objective 24 of the National Objectives and Directive Principles of State Policy obligates the state to promote and preserve such cultural values and practices as envisaged as the collective dignity and well-being of Ugandans. This state obligation is echoed in Objective 14A, which obligates to ensure that all development efforts are directed at ensuring the maximum social and cultural well-being of the people. Furthermore, this court is under Article 126, Clause 1 of the Constitution, obliged to exercise its judicial power in the name of the Ugandan people and in conformity with the law and with the values, norms, and aspirations of the people. Uganda's social cultural norms, values, and aspirations are summed up in Objective number 19 of the Constitution's National Objectives and Directive Principles of State Policy, as well as Article 31A, 2A, and 37 of the Constitution. There is no global consensus on the universality of the rights grounded in sexual orientation, gender identity, gender expression, sex characteristics. Hence, to date, non-discrimination on the basis of subject variables not found to international human rights treaties. It has been vetoed by a bloc of resistant UN member states that has prevented the adoption of a binding declaration strengthening protection of LGBTI human rights. 23. Case law on the subject differs from jurisdiction to jurisdiction. In the case of Navitya J. Singh versus the Union of India, the Indian Supreme Court held that consensual carnal intercourse among adults, be it homosexual or heterosexual, in private space, does not in any way harm the public decency or morality. That decision was grounded in the notion of constitutional morality, supposedly harmless nature of the consensual homosexual rights, and the rights to individual autonomy. However, we are unable to follow that decision for the following reasons. A, the notion of an individual's unfettered sexual autonomy defies the logic of offenses like incest, bestiality, and other unnatural offenses that are still on our statute books. B, we respectively do not share the view that the pleasure derived from an action would negate its criminality, otherwise offenses like rape and incest would be devoid of criminality. C, with regard to the alleged absence of harm in private, consensual acts of homosexuality between adults, the health data and evidence on record indicate that men who have sex with men, NSM, and transgender people are particularly at risk of HIV infection. A survey report posting that 13.7% of the in Kampala, Uganda, were found to be living with HIV.
In our view,
Anal sex causes physical harm. HIV infection represents serious harm to physical and mental health, and they both place an increased disease burden on the finite budgets of lower income countries. It is a most legitimate and compelling state interest that would negate connotations of arbitrariness in the legislation of Uganda's Anti Homosexuality Act. D. The Indian Constitution is fundamentally different from the Ugandan Constitution in the following ways. 1. It does not contain the equivalent of Article 8A of the Uganda Constitution that constitutionally entrenches governance based on the principle of national interest and common good. 2. Its directive principles of state policy are not just judicially enforceable. 3. It does not contain the equivalent of Article 126(1) of the Uganda Constitution, which obligates the Uganda judiciary to exercise judicial power with regard to the law, as well as the values, norms, and aspirations of the people of Uganda. 4. The Indian Constitution contains no provision that sarcastically proscribes marriage between persons of the same sex, which is an indication of the societal aspirations of the Ugandan people. We therefore find that sections 21, 21, 24, 31, 32C, F, H, and J, 3 and 4, 5, 1, 6, 9, 11, 2D, and 16 of the Anti Homosexuality Act do not violate Article 24 and Article 44A of the Constitution. We accordingly resolve issue number 8 in the negative. Issue number 7, right to equality and non-discrimination. 25. The drafting history of Article 21 and 31 of the Ugandan Constitution reveals that there was a deliberate omission of sexual orientation as one of the parameters of discrimination. The 2005 Constitutional Review exercise reveals that legislative views on the need to protect homosexual family has not changed. Anti-Homosexuality Act has not changed. The subsequent enactment of the Anti-Homosexuality Act affirms this view. The legislative background distinguishes the Uganda constitutional dispensation from the one of Kenya, South Africa, and India. Consequently, we do not find that sections 1, 2 to 4, 3, 1, and 3, 2C, F, H, J, 3, sub-article 3 and 4, and 6 of the Anti-Homosexuality Act contradict the right to equality and freedom from discrimination guaranteed under Articles 21, 32, 43, and 45 of the Constitution. On the other hand, the disqualification, these sexual convicts from employment in child care institutions under Section 12 and 13 of the Act is, in our view, intended to protect children and vulnerable groups in society. This is a legitimate objective under Article 17, sub-Article 1C, and Article 34(7) of the Constitution. Therefore, that limitation on the right to non-discrimination is proportional to the child protection objective of Anti-Homosexuality Act. It is demonstrably justifiable in a free and democratic society as envisaged under Article 43(2) of the Constitution. Issue number 7 is accordingly resolved in the negative. Issue number 9, the right to privacy. The 7 of the Constitution prohibits unauthorized searches of a person, home, or property, as well as unlawful entry onto another person's property. and confers freedom from interference with the privacy of one's home or other property on the confidentiality of one's correspondence or communications. We do not find the impeded sections of the Anti Homosexuality Act to authorize unlawful entry onto or such interference with a person's body, home, or other act, correspondence, or communication. The right to privacy, in its mere generic sense, is depicted in Article 12 of the Universal Declaration of Human Rights, Articles 1, 17, 2 of the ICCPR, and Articles 22 of the ICHPR. We find Article 1 of the SPR and Article 22 inapplicable to the rights of privacy, and thus no violation of those provisions within the concept of privacy. On the other hand, we find no inconsistency with sections 1, 2, 3, and 9, and 11, 2D of the Anti Homosexuality Act, and the right to privacy enshrined in Article 7 of the Universal Declaration of Human Rights and Article 17 of ICCPR. However, we find the mandatory reporting obligation under Section 14 inconsistent with the right to privacy encompassed in Article 12 of the UHDR and Article 17 of the ICPR. The right to health, as enshrined in Objective Number 14 and 20 of the National Objectives and Directive Principles of State Policy, and Article 12.1 of the ICESSR. The protection of family, as envisaged in Objective Number 19 of the National Objectives, and freedom to practice any religion, as encompassed in Article 29(1)(c) of the Constitution. Consequently, issue number 9 partially succeeds. Issue number 10 and 11, right to freedom of expression, thought, and association. The Anti-Homosexuality Act criminalizes the receipt and importation of ideas and information that are deemed to promote and encourage homosexuality. The discrimination of academic views that seemingly promote or encourage homosexuality, and associations that engage in activities that amount to financing, encouraging, or promoting homosexuality. It thus imposes limitations on rights to freedom of speech or expression, freedom of thought, conscience and belief, and freedom of association. We do not consider the nature of expression contemplated under Article 29(1)(a) of the Constitution to extend to the expression of sexual intimacy as proposed by the first to eighth petitioners. In our view, freedom of expression, in the sense it accrues under the Constitution and ICCPR, entails mental thought that is expressed verbally, in writing, or by sign language, and not necessarily physically. Otherwise, the permissibility of a rights limitation hinges on two broad criteria. A, the objective or purpose of the restriction must be sufficiently important, pressing, or substantial as not to give traction to triviality. 2, the means chosen for the attainment of the limitations objective ought to balance societal interest with the interests of individuals or groups. 33. This balance should be assessed on the basis of a proportionality test that has the following elements. A, the measures adopted should be rationally linked to the objective sought to be achieved. B, even if so rationally linked to the objective, the measures should impact as little as possible on the restricted rights of freedom. And C, the effect of the measure should not be so severe as to discredit the objective or purpose of the restriction. 34. The evidence on record is that the Anti-Homosexuality Act was enacted against the backdrop of recruitment of children into the practice of homosexuality. That is the mischief that Section 11 of the Anti-Homosexuality Law seeks to address. Section 11 of the impinged Act reflects that society's aversion to what is deemed an affront to public morals or social sensitivities, and thus abides the permissible limitation under Article 29(3) of the ICCPR. Consequently, the legitimacy of the Anti-Homosexuality Act is unassailable. Furthermore, there is a direct and rational nexus between the prescriptions against the promotion of homosexuality embedded in Section 11 of the Act and the objective of the impinged law. In our judgment, Sections 11 and 2C and E of the Anti-Homosexuality Act are not so severe as to undermine the delicate balance between societal and individual group interests. Rather, they simply represent the composite position of the law to ensure the operations of NGOs with due regard to the prevailing laws. We therefore find that Sections 11(2)(c) and E of the Anti-Homosexuality Act are demonstrably justifiable in a free and democratic society. We therefore find no violation of Article 29(1)(e) and 38 of the Constitution. 36. Similarly, the Anti-Homosexuality Act, having criminalized homosexuality, it follows that any usage of property that is contrary to that law would run afoul of Articles 8A and 242 of the Constitution. In any case, we find no violation of the right to assembly under Sections 11(2)(d) of the Act. Relatedly, Section 11(2)(b) of the Anti-Homosexuality Act resonates with Section 31 of the Uganda Communications Act and Section 13 of the Anti-Pornography Act, all of which seek to preserve societal morals by restraining the use of media communication to publish, broadcast, and disseminate offensive material. These limitations, freedom of expression, are legally permissible within the confines of Article 19(2) of the ICCPR. On the other hand, the scope of academic freedom is restricted to intramural expression and or publications within a university or academic context, and to a lesser degree subject to determination on a case-by-case basis the extramural expression that ensues outside the academic context. Extramural expression may, in any event, be subject to such restrictions and limitations as are recognized under Article 19(3) of the ICCPR, as well as the dictates of Article 43 of the Uganda Constitution. In the result, we find that Sections 2 and 3 of the Anti-Homosexuality Act are not inconsistent with the right to freedom of speech and expression embedded in Article 29(1)(a) of the Constitution. In Section 11 and 22(c) of the Act does not violate the right to freedom of religion encompassed in Articles 29(1)(c) of the Constitution. Furthermore, we find Sections 11 and 2B, C, and E of the Act to represent permissible rights limitations within the confines of Article 8A and 43 of the Constitution, and therefore constitutional. Accordingly, issue number 11 and number 10 and 11 fail. Issue number 12, the right to practice profession, carry on lawful occupation and business. The nature of economic rights envisaged in the individual right to practice one's profession and carry on any lawful occupation, trade, or business. With the greatest respect, we do not abide the view that the right of religious leaders or organizations to enjoy the uninterrupted use of their leased premises or cater for disadvantaged persons necessarily mandates them to constitutional protection for persons so housed that are engaged in unlawful activities. We therefore find no violation of Article 40, Article 2 of the Constitution by sections 11(1), 2(d), and E of the Anti Homosexuality. On the other hand, we respectfully find no nexus between sections 2, 3, and 9 of the Anti Homosexuality Act and Article 42 of the Constitution. Sections 2 and 3 of the Anti Homosexuality Act create the defense of homosexuality. These are not occupations, not trade or business. Neither, for that matter, is the use of premises for homosexuality that is prescribed under section to an occupation, trade, or business. In any case, section 9 of the Act does not obliterate anyone's right to their profession, occupation, trade, or business. With regard to section 12 and 13, Articles 43 of the Constitution permits limitations to constitutional rights that are protected by the Constitution itself. This is in tandem with an established rule of constitutional interpretation that the entire Constitution has to be construed together as an integral whole, with no particular provision destroying the other, but each sustaining the other in order to reduce the intention of its framers. Having under our interrogation of the right of privacy pronounced the constitutionality of section 14 of the Homosexuality Act, we abide our earlier decision and do not find it necessary to consider the same arguments here. We therefore find that sections 2, 3, 9, and 11, 2D and E of the Anti Homosexuality Act are neither inconsistent with nor in contravention of Article 40 of the Constitution, Article 22 of the Article 1 of the ICCPR and ICESRP, and Article 8P. Furthermore, insofar as they seek to protect children and other vulnerable members of society, as provided for in Article 17(1)(c) and Article 34(7) of the Constitution, the rights, limitations enshrined in Article 12 and 13 of the Act are constitutionally permissible. We accordingly answer issue number 12 in the negative. Issue number 13, right to health and property. The petitioners argue that sections 2, 3, 12, and 13 of the Act hinder the right to LGBTQ1I and Ugandans pursue their social and cultural development as guaranteed under Article 22 of the UDHR, Article 22(1) of the ACHRP, and Article 1 of the ICRC, insofar as they constrain the principles of self-determination and free development of one's personality. The constitutionality of Article 2 and 3 of the Anti-Homosexuality Law vis-à-vis the rights of self-determination and personal self-development were interrogated alongside the right of dignity and social conditions under issue 8 above. We abide our conclusions therein and find no reason to reconsider the same question here. We do not find any inconsistency between Section 17 of the Act and the socio-economic rights highlighted above, given that it is simply mandates the responsible public official to make subsidiary legislation for the implementation of the Act. We similarly reiterate our findings under Article 9 that Section 14 of the Act is inconsistent with the right to health. In any case, had we not pronounced ourselves on its constitutionality, we take the view that the reporting obligation under Article 14 would indeed have a chilling deterrent effect on access to health care by homosexual patients afraid of being subjected to criminal prosecution. With regard to Section 12 and 13 of the Impeachment Act, it seems to us that the limitations to the full enjoyment of the right to self-determination, personal development, are not only constitutionally within the precepts of Article 17, 1C of the Constitution, they are in tandem with the provisions of Article 29, 2 of the UHDR. Each one then endorses the limitation of rights that are prescribed by law and are intended to protect the rights and freedoms of others for the general welfare of society. In relation to the more specific rights of property and health, Sections 9 and 11(2)(d) of the Anti Homosexuality Act do not deprive a defaulting property owner of his property. Rather, they are blind prohibition in respect of property use, lease, or licensing. The penalties for which are custodial sentences for natural persons and suspension of organizations' operation license. To the extent that the privatization of property does not require no violation of Article 26 of the Constitution. Nonetheless, Article 25(1) of the UHDR and Article 11 of the ICRC recognize the right to an adequate standard of living for everyone, to include housing and medical care. Legal provisions that have the effect of not simply restricting the right to housing, but totally denying homosexuals access to housing, are unduly deliberative and unjustified in a free and democratic society. In this case, we think that Section 9 and Section 2D of the Impeachment Act have the additional effect of compounding homosexual persons' sustainability to mental health problems. Meanwhile, the unintentional transmission of HIV finds no justification in criminal law, in as far as it defies the element of criminal intent or mens rea, which is a vital component of the concept of crime. This indeed is the approach that was adopted in Section 43 of the HIV and AIDS Prevention and Control Act 2015, which restricts criminal culpability to the intentional transmission of HIV. We therefore find that Section 32C of the Anti Homosexuality Act perpetuates the susceptibility of persons that are HIV positive to mental health issues and thus impedes their right to enjoy the highest attainable standard of mental health. This is a violation of the right to health as envisaged under Article 12 of the ICRC and is inconsistent with Article 45 and 85 of the Uganda Constitution. With regard to Sections 1, 2, 3, 6 of the Act, we find that the Uganda National Health Policy constitutes significant policy interventions directed at particularly vulnerable section of society, the LGBTQ community, and represents significant steps undertaken to ensure non-discrimination of LGBTQ persons in the provision of health services. With specific regard to HIV/AIDS interventions, we are aware that attempts to legalize against homosexuality dates back to 2014, where the first anti-homosexuality bill was passed. Before that, the country had historically included on statute books the crime of unnatural offenses that would have included anal sex. There is no evidence to support the view that apparent aversion to homosexuality was any less then than it is today, but despite the existence of these laws, Uganda made significant progress in the right to health with specific regard to HIV/AIDS. Against that background, it is inconceivable that the enactment of anti-homosexuality law would so impact the trajectory of HIV prevention, treatment and control in Uganda as to amount to demonstrable retrogression. In any event, the Committee on Economic, Social, Cultural Rights did, in general comment number 14, highlight the four elements of availability, accessibility, acceptability, and equality, AAA2, which are considered essential to the enjoyment of the right to health by all, as enshrined in Article 12, Sub-Article 2D of the ICESCR. Acceptability in that context requires that health facilities, goods and services are respectful of medical ethics, cultural appropriate age, and gender sensitivity. In the words of the Human Rights Face Sheet number 31 of the Human Right of the Right to Health, they should be medically and culturally acceptable. We construe this to mean that all persons and organizations that serve in the health sector, particularly community-led and community-based NGOs, should be mindful of the law, policies and cultural sensitivities of communities within which they operate, and refrain from conduct or activities that defy them. Communities affected by HIV, as well as any lingering societal or substructural contradictions in respect of HIV-related services, resources, and tools, ought to be approached accordingly. In the result, we find that Section 3(2)(c) violates the right to health enshrined in Articles 12(1) of the ICESCR and recognized under Article 45, 287 of the Uganda Constitution, while Article 9 and 11(2)(d) of the Anti Homosexuality Act are inconsistent with the right to adequate standard of living enshrined in Article 25 of the Universal Declaration of Human Rights and the right to health enshrined in Article 12 of the ICESCR. Similarly recognized under Article 45 and 87 of the Uganda Constitution. However, we do not find Sections 1, 2, and the rest of Sections 6, 11, and 2E and E of the Impinged Act to be inconsistent with or in contravention of Objective 14B and 20 of the National Objective and Directive Principles of State Policy, or Articles 45 and 87 of the Constitution. Consequently, issue number 13 partially succeeds. Issue number 14, remedies available to the parties. The petitioners sought a myriad of remedies that essentially call for the nullification of the entire Anti-Homosexuality Act 2023. Having held as we have in the body of the judgment, we decline to nullify the Anti-Homosexuality Act 2023 in its entirety. Neither would we grant a permanent injunction against its enforcement. We, however, adjudge sections 32, section 3, sub-article 2 and C of the Act to violate the right to health enshrined in Article 12.1 of the ICECR, Section 9 and 11, Subsection 2 and D of the Act, to infringe the right to adequate standard of living lined in Article 25 of the Universal Declaration of Human Rights and Article 11 of the ICCR, as well as the right to health and Section 14 of the Act, to be inconsistent with the right to health, privacy, and freedom of religion that are respectively recognized under Article 12 of the Universal Declaration of Human Rights, Article 14.1 of the ICC, and Article 29.1c of the Uganda Constitution. It will suffice to observe here that provisions of the international instruments to which Uganda is a party gain recognition in Uganda's constitutional dispensation on account of Objective number 28B and National Objective and Directive Principles of State Policy and Articles 45 and 287 of the Constitution. It is quite law that costs follow the event unless a court for good reason decides otherwise. Case law abounds on the wisdom of not condemning losing parties to costs in the public interest litigation. It is abundantly clear that this petition has conversed matters of grave national importance and immense public interest. Consequently, the circumstances of this case do not warrant a departure from the general rule on costs. Consequently, the circumstances of this case do warrant a departure from the general rule on costs. Disposition. The upshot of our judgment is that this petition substantially fails with the following orders. A. Sections 3, subsection 2C, section 9, 11(2), D, and 14 of the Anti Homosexuality Act 2023 are hereby struck down. Each party shall bear its costs. It is so.